Okay, so we're going to talk just a little bit about procedure in terms of divorce and custody law. And this applies to every state because it's just some general information. If you have written a complaint, like in civil procedure, you remember that the advice that was given you, and you should all have taken civil procedure before, right? Was take a look at your, let's say it's a negligence claim. And we're going to take a look at the elements of negligence. And so we're going to allege all of those. And then for most states, we're going to notice plead, right? We're going to give you a short and plain statement of the claim. So some of that, if you look at the rules, you'll see it has to have a caption, it has to have numbered paragraphs, and it has to show certain things like the jurisdictional statement and the venue. And then what constitutes negligence or whatever other claims you choose to bring is up to you. So it's maybe 30% true, just straight looking at the statute. This is what it needs to have. And then it's about 70%. What do I think I can bring based on my facts? Do I have negligence? Do I have negligence per se? Do I have an intentional tort as well? And you have to make those decisions on your own. Then you have to figure out how to specifically allege duty breach causation damages, let's say if it's a negligence claim. All right. If you pull up the same, and I can give you some examples of some competing petitions under Indiana law, not petitions, civil lawsuits. You have the same exact case, same litigants, same fact pattern. Two complaints by two different lawyers can look structurally similar, but substantively very different because I'm going to choose what claims, and those might differ. I might think I might be a throw everything against the wall and see if it sticks kind of a lawyer, or I might be the kind of a lawyer that says I'm just going to file the best claim, what I think is the winner. All right. And the actual detail to those claims, how you allege them, how you discuss duty breach causation damages might vary substantially. Some people use bullet points, some people use numbers, some people just write a statement. Almost everybody uses a header. So if I have in a civil complaint, if I have a negligence claim and an intentional tort claim, I'm going to put a header over both. But I've seen people that don't do that as well. It makes it more difficult to read, but that is part of the art of lawyering. What is good for you and will apply to your last assignment, not so much to the final because I'm not making you draft anything in the final. I'm just making you answer a substantive question. Is that in family law, it is much, much easier. Family law is 70, 80, 90% that first part. Did I follow the statute? Did I allege that the parties were married on such and such a date, separated on such and such a date, lived in the state of Kentucky for such and such period of time? And the only substantive part, remember, because 99% of divorces are no fault. What's the substance of that? I don't want to be married anymore. And that's where you use the language of irretrievable breakdown or irreconcilable differences. If we were talking about like a fault-based divorce, then we would have that, here are all the things my partner did that fall under the statute, and on such and such a date I found them uh, somebody else pregnant with his child. That's where you would put the substance. That doesn't exist with a no-fault divorce. So it makes pleading a divorce far easier than pleading a civil lawsuit, which is good for you for purposes of this course. In addition, the other thing that makes the procedure much easier on lawyers and pro se litigants is that this is an area of law where there is a lot of pro se litigation. Because of that, courts all over the country have created pro se forms. In any state that I know of, I don't know many exceptions to this. If you are a pro se litigant and you want a divorce, you want custody, you want other family law matters, you can find sample petitions, and many of them are fill in the blank. Click, 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 file. Pay the filing fee, and you're done. You can use any of these resources to create the petition in your last assignment. I've pulled up the Kentucky Self-Help, and very often it's called Self-Help. It's called that in Indiana, and it's called that in Kentucky. In Kentucky, it's a website called kyjustice.org, and I'll post this as well. It's got self-help divorce options for Kentucky residents, and you just pick the one that applies to you, with kids, without kids. You can get paper forms. There are packets on self-help, how to file a divorce, what I need to do for with children, without children. And then there are some other domestic violence protection orders, custody, child support guidelines. All of that is in the legal self-help section in KY Justice. So take advantage of that. We do not reinvent the wheel when it comes to a divorce petition. We don't do it with a negligence petition, but it makes more sense too, because not every car accident is the same. Every divorce is the same if it's no fault. The only thing that changes are the names and the addresses and the times. That's it, and that's so easy. So we don't reinvent the wheel. We use petitions we find online. We use self-help forms. You can use those self-help forms to help you draft your own petition. Now, I can't have like a screenshot of clicks. I need you to draft it, but it's really simple. And it is so simple that judges very frequently don't need to be concerned with the substance of it, because if one party wants a divorce, they get it. That's what it is. I don't have to convince somebody. There's no burden of proof. I don't have to convince somebody to a preponderance of the evidence that so-and-so was at fault for hitting my car. So from a pleading standpoint, from a civil procedure standpoint, family law is far easier. I don't have to convince anyone of anything. There are a few terminology differences. Instead of a complaint, we call it a petition, but we still call it an answer. The answer to a family law petition is very often just as straightforward as the petition is, because we're not alleging any affirmative defenses. There is no affirmative defense to, and you should remember this from civil procedure. You have your petition, right? You have your answer that responds to all of the numbered paragraphs. Same thing for family law. Or your complaint would be the civil procedure. If it's family law, it's going to be your petition, and the answer is going to answer all of those individual numbered paragraphs. But then in civil procedure, your answer can go on to create or allege affirmative defenses. And I have a couple of examples of those that I can post to show you the difference between pleadings, but that's really civil procedure instead of family law procedure. Your answer is just going to answer it. There's no affirmative defense to, I don't want to be married to you anymore. What? Yes, you do? No, we don't do that. We don't fight about whether or not one person really wants to stay married, because if they did, they wouldn't have filed for divorce. So it's far more straightforward, far easier in that aspect. And an example of this I can give you from real life is when I was clerking. I was clerking in Norfolk, Virginia for the trial court there. We had 4 clerks, and there in a jurisdiction next door, Virginia Beach, there was a permanent law clerk, and none of us can understand it, because law clerking is typically, right, you get the job right out of law school and you're just there for a year. So why would you need a permanent clerk? Because they also had the temporary year ones. This permanent clerk did almost nothing but review divorce petitions, and I'll tell you how she did it. The judges in Virginia Beach were very concerned that the statute was followed completely and precisely. So this clerk on a daily basis would pull up the statute, pull up the divorce petitions that were filed that week, and see, is number 1 is jurisdiction here. Number 2 is this here. Number 3 is this here. It was rote. So it was definitely the job for a perma clerk, is what we called that person, because it did not involve any litigation. It didn't involve any representation of clients, and it didn't involve a whole lot of high-level thinking that a judge might have to do, might rely on those temporary clerks for. IRAC's research and writing, and she did some of that too. But I can't stress enough that petition writing in family law is easier, more straightforward, and it must follow the statute when compared with civil procedure for civil lawsuits. So take all of those skills you learned in civil procedure last year or the year before, and understand that learning those now makes learning the civil procedure in a divorce petition. Same for custody, same for support. It's very, I would say custody and support, which is why I told you if you want to choose those, they are more difficult. Because for support, you do have to allege, let's say you're filing a petition to change custody or change support. You do have to say why. Still super easy though, because even when you look at the procedure for filing a custody change or a support change, what do? We talked about this a few weeks ago. When can we change child support? Depending on the state, and you'll look at your statute, once a year, or if there's a significant change, like somebody wins the lottery or somebody gets disabled. So that's what you allege. You pull up the statute, you say, ex-husband won the lottery, give me my child support increase. You don't have to think, gee, what do I file here? Should I go for negligence? Should I go for, it's not, you don't have to think as much. For any family law petition in terms of procedure, you pull up the statute, you follow the statute. That is it. And that's the same for child support, child custody, spousal support, adoption, all the family law stuff. You pull up the statute and you follow it. The only things you might add are guideline calculations for things like child support, and in Kentucky they use guidelines for spousal support as well. But you don't have to invent anything, and you don't have to sit down with your case file and determine what your best causes of action are, because they are so straightforward. In terms of drafting the petition, pull up the law, and you may see certain requirements. We've talked about them before. For jurisdiction, for instance, you have to have lived in your state for a period of 3 months or 6 months, in your county for a period of, whatever the statute says. So then you go through your interview with your client and you add those. That is it. It makes the civil procedure portion far easier. Remember that there may be service components as well. Those are typically the same. I will say be careful, because previously we looked at the fact that Kentucky has not only civil procedure rules, but a special family law section for rules, and those are going to contain your service. So in a petition, you might have a special summons that says something a little different than the standard summons. Remember that a summons, when you file a complaint, you file a complaint and you file a summons, and that summons lets the other side know that they've been sued. There are similar notice provisions for summonses and for how we serve a petition on the other side. But all those they're still very statutory, follow what this says and do it. And they give the other side notice. So there's not much difference in terms of summonses and notice requirements, or serving appropriate service to the other side. And then that's it. We have, as far as civil procedure is concerned, we have a lot less. There's not a huge call for discovery. Yes, there is discovery, but many family law disputes are resolved without it. I don't know anybody who's gotten divorced or who's gotten child support different calculations changed, who had to go through a significant process of discovery. Understand, from a civil law standpoint, from a civil procedure standpoint, we still have those tools in our toolbox. If we get to the point where, let's say in an equitable distribution of a divorce, that we think our spouse is hiding assets, then we absolutely can file interrogatories. We can file discovery. And some of that does happen, but for the most part, people can resolve their disputes without it. But we can do all of those things. If I think that the child support is being miscalculated because my spouse is hiding a job, I can do that discovery. I am not going to make you do that for purposes of this class, because that's a relatively small section of the practice. In addition, there's not a lot of true trial work. We may have hearings, but it's pretty rare to have a full-blown trial on any family law issue. It happens, but that's for experienced practitioners, because it is pretty rare. It doesn't happen very often. So in terms of civil procedure, those are the highlights. If I think of anything else that I can add, I will follow up with this, but that will give you somewhere to go for the civil procedure portions of this course and for your next assignment. As always, email me with any questions.